in litigation nowadays, the new normal. So how the arbitral tribunal and the arbitrators and how this new normal can be adopted in domestic arbitration and international arbitration. And I believe it depends upon the hosts, but I believe we will also be addressing the questions of the participants, if any, if they have any queries or questions, or if they have anything to ask regarding the arbitration procedure international. So we will be addressing those queries also, I believe. So I think we can start with the actual session. With depends upon the hosts. Over to hosts, please.
Yes, sir. So, sir, first there are some questions from the side of moderators. Then along the way, when we discuss some of the topics and the subtopics, we'll be going towards the audience for the questions. So, sir,
Right.
first question from my side is to you, Sagar, sir, followed by
Yes.
Baskaran, sir. Sir, a significant impact of COVID is on the delayed enforcement of the awards. As we
Right.
say that justice delayed is justice denied, is the
Absolutely.
effectiveness of arbitration under danger?
See, it would be absolutely incorrect to say if the effectiveness of arbitration is in danger. I would not say that it is in danger, but this is a difficult time for everyone, including the arbitrators, including the tribunal, including the litigants who are before parties who are before the arbitral tribunal. So I would not say enforcement or future of arbitration is in danger, but yes, it is a difficult time. And yes, absolutely, no one can deny this fact that enforcement of arbitral awards has been delayed, and parties has suffered a lot during this COVID times, because having an award in your favor means you are the decree holder, and despite being the decree holder, you do not get the benefits. Decree means you are to reap the benefits of your litigation, but despite being the decree holder, you have not reaped the benefits of your decree as on day. But I believe as and when the situation goes along and it will be improved, the enforcement execution of arbitral awards will take place. And I believe if the award has the pending interest till recovery or till realization, then the party will get the benefit of that realization of interest also during the pandemic time.
Right, sir. Sir Bhaskaran, sir, your views on this?
Yeah, thank you for the question, Arush. Well, generally, I think in most jurisdictions, we're speaking about enforcing an award here. So usually it's done by way of an application that's supported by an affidavit. The advantage, of enforcing an award as opposed to any other proceedings in court is that witnesses don't need to be called and there is no trial. You simply have an application that's supported by an affidavit, and that affidavit will have a copy of the arbitration agreement and the arbitral award exhibit. In various countries, there are still restrictions and the courts are not fully operating. These particular types of application are very suited to being heard by way of virtual hearings, because there's no need for witnesses and things like that. And the application can simply be filed into court. And if the particular jurisdiction allows for matters to be heard virtually, then those virtual hearings can be held and the award can be enforced. The award itself, and the enforcement proceedings to some extent, they don't usually involve very lengthy proceedings, especially if there is no application to set aside the award. So in my view, it would be particularly suited to that. There are, of course, various jurisdictions where virtual hearings are being held. In India, I understand that they are being held. They're certainly being held in Malaysia, in London, and in Singapore.
Yes, so a very valid point that is raised here is amounting to virtual hearings. So, sir, as to the rules of ICC 26.1 and the New York Convention Article 51B, there is a mention of hearing. So for the purpose of the benefit of this webinar, sir, can you please expand the meaning of this, the word hearing? Because hearing in the past meant that it should be in person. But as the situation have changed, many of the tribunals and under this convention, the virtual hearings are permitted. So, sir, according to the rules, is virtual hearings in the mandate of these particular conventions? So, this is addressed to both of the panelists. Anyone can take it first.
Baskaran sir, are you taking it or should I take it?
Yeah, I can take it. I mean, of course, I suppose when these rules and these conventions were entered into force, perhaps we didn't anticipate such a protracted period of lockdown where courts would not be operating. But that having been said, virtual hearings are not actually something entirely alien to arbitration, even prior to this pandemic. Arbitration, by its nature, was a procedure set up to resolve disputes on an international basis. And one way of doing that more conveniently was obviously to have virtual hearings. So I actually have done an arbitration in Mumbai about 6 or 7 years ago, where although not the hearing where witnesses were called were all held in person, but where there were applications, for disclosure or for security for costs, they were actually held virtually because, you're just going to hear an application. It can quite effectively be done by way of video conference virtually. Insofar as cross-examination of witnesses are concerned, I mean, I think technology has developed to the extent where it is quite effective. And various people have actually commented that, insofar as observing the demeanor of a witness and things like that are concerned, it is actually, to some extent, it's actually surprisingly more effective when it's done by way of video conference as compared to when it's done in person. Simply because, just like you're looking at me now and I'm looking at you, your expression and your feature and your demeanor is all framed within a screen, and in a way it's easier to observe someone that way. I suppose we're all used to observing people on screens. When we watch movies, we watch television, so something everyone is actually a bit more used to than they think they are. Yes.
Sagar, sir.
Yes, please. I absolutely concur with everything Baskaran sir has just said. And I just want to add 2 or 3 more points to it. See, arbitration, I believe, is not a way of conventional litigation. It is a flexible form of dispute resolution, and it all depends upon the party autonomy. In an arbitration proceeding, the arbitrator, it depends upon the tribunal and depends upon the agreement and arrangement between the parties before the tribunal. And I believe the arbitral tribunal has the absolute power in India. When we talk about Arbitration Act, in Indian Arbitration Act, we have Section 19, which absolutely says that tribunal is not bound by the rules of CPC or Evidence Act, meaning thereby the arbitral tribunal can decide the dispute between the parties on the basis of claim, reply, or the documents placed by the parties on record. That is all required by the arbitrator to decide the dispute. And a recording of evidence is not a mandatory procedure in case of arbitration. So this is one point. It all depends upon the party autonomy. See, the arbitrator will have to the arbitral tribunal, the infrastructure of the arbitral tribunal needs to be developed. The arbitrator will have to accept these changes. I have seen, as far as lawyers appearing before the arbitral tribunal is concerned, I have seen before Delhi High Court Arbitration Center, most of the lawyers appearing and arguing, they refer to documents from their laptop, iPads. They argue from the entire set of document is in e-form with their system in laptops or iPads. So as far as the tribunal is concerned, the tribunal will have to adapt this change and their infrastructure needs to be developed. As far as international arbitration is concerned, video conferencing is not a new norm, and international arbitration has adopted this practice of appearing before arguing virtually long before COVID times, because the parties are from different countries. And in as much as the arbitration core Indian parties are concerned, we have Indian Council of Arbitration rules. If you'll go through rule 16 is jurisdiction, rule 17 is the procedure to be adopted by the tribunal. If you'll go through rule 17, it clearly states that the tribunal can have the hearing by means of any virtual mode. Any virtual mode that includes also telephonic hearing can also be done there. So it depends upon the powers that how the arbitral tribunal exercises those powers. So obviously these are the difficult times, but still the dispute resolution must go on, and arbitration procedure is such flexible in nature, and it is left to the autonomy of the parties. And a procedural order, I believe, because in some cases I am also acting as an arbitrator, and I have been appointed previously also as an arbitrator in most of the cases. So the arbitrator, when he is holding the arbitral tribunal, in these times he can issue a procedural order, and in such procedural order he can clearly specify what should be the procedure, and as SOP may be issued by him for appearing before him, for arguing before him, for serving any document. I'll discuss the confidentiality later on, but confidentiality of documents which are being served to other party or to the tribunal. So a standard procedure can be adopted by the tribunal itself, because tribunal is absolutely empowered with all these duties and responsibilities under the act itself.
Yes. So, sir, on the same lines, one point was raised here that the courts may not be functioning well due to this COVID situation. So, sir, now I want to ask a question in reference to bilateral investment treaty. Bilateral investment treaties usually have a clause of domestic remedies, that in order to obtain an international remedy or a remedy under IEC, SID, first domestic remedies have to be sought out. So, sir, in the situation where the courts are not working properly, can it be taken as an exception? Sir, this question is directed to Baskaran sir, followed by Sagar sir.
Yes, well, I mean, the provisions that are found in investment treaties, where you cannot obtain a domestic remedy, and because of that, you need to proceed to investor state arbitration. I mean, well, firstly, as I said, in many jurisdictions, the courts are operating virtually. Here in Malaysia, in fact, the lockdown has been lifted since the 4th of May, and things have been operating since then, and we have had various in-person hearings in court since the 4th of May. But in jurisdictions where it has yet to be engaged, where lockdown has yet to be lifted and courts have yet to commence operation, I don't think the provisions under an investment treaty would be engaged, because obviously there are here extraneous circumstances that are preventing those court proceedings from taking place. They may, it may come within the right of a state to regulate insofar as public health is concerned. So we saw that to some extent, in the Philip Morris case, where there were regulations in terms of plain packaging for cigarettes. So here, similarly, there is to some extent regulation for public health concerns, and I don't think that this can be used as a basis for saying that it's a remedy cannot be obtained from local courts at this juncture.
Sagar sir?
Absolutely. I believe when it comes to availing the remedies in the domestic circle, who are the international treaty between the contracting parties, So it all depends whether what is the exact situation, or whether the courts are functioning in such jurisdiction or not. When it comes to India, most of the courts are functioning virtually, and day in day out we used to appear virtually, and even the urgent filings are allowed over emails, and filings are allowed, and e-court system has also been placed into operation now. So all such domestic reliefs in India, if it is in India, then it can be sought by way of the eve procedure. And if the physical hearings are allowed in districts, some districts have allowed the physical hearing. If the physical hearing is going on in such district courts or in the high courts of the respective districts, then such physical hearing may kindly be attended. Or if no such physical hearing is allowed, then virtually all the courts in India are functioning as on day. So when it comes to availing the remedies under domestic laws, qua the international treaties, international agreements between the parties, then parties are free to approach. And the only problem remains is when the other party, the one party might be from India itself, the other party may be from any other country. So the party who is from India is obviously on the upper hand at this time, because the party who is not in India at this time, he will have to face some difficulty. Though there are flights commuting by government of India, but for regular hearings and for everything, it would be very difficult for such party to approach to the courts in India at this time. So they can appear virtually, even they can make a request, and they can appear virtually before such courts. So I think when it comes to domestic arbitrations, or when it comes to domestic uh, availing remedies under domestic laws, then in India it is all way open. And if it comes to the jurisdiction of any other country, then it depends what the procedure, what the position is in other country, whether the courts are functioning or not. But I believe all over the world the courts are not shut down absolutely, and all the courts across the world are hearing matters on the grounds of urgency, and on the grounds of if irreparable loss is being caused to any party, the courts are always open. So this is how the parties can approach the court, availing domestic remedy also.
Adding to this particular point itself,
Okay, sir.
that when as the courts are working virtually, so even in the arbitration matters, the witnesses which are being brought are also working. Are so? Is there any issue being faced by any of the person as the witness? We can see a lot of body language changes. A body language is very much important in the case of arbitration, and while testifying a witness, or while having a witness statement. So what is the issues being faced when a witness is there during these virtual proceedings? So to Sagar, sir.
Yes, but I absolutely agree with you. There are several issues day in day out we face whenever we are called upon to for witness examination in arbitration proceedings. So in many of the cases, we have requested the tribunal to issue a proper SOP for the witness to appear virtually before the tribunal. So the standard before the cross examination or examination in chief, at first the SOP must be issued by the tribunal at first, and the SOP includes that how the witness should appear, at what place the witness should appear, and how. For example, I'll just give you an example that a witness was directed to appear, and a large mirror was directed to be set up behind him, so that no witness influence or no other person could be present in the room, and if it is so, such may be reflected in the mirror itself. So these are the standard procedures which the tribunals are adopting these days, and which are mandatorily required, which should be mandatorily required by all the tribunal. As far as the issues which we as a lawyer face while cross-examining the witnesses, sometimes when the witness is present in person before us, or before the tribunal, when we are examining him before the tribunal, lawyers, over the period of time, we usually work upon the intuitions and vibes which are coming from the tribunal or coming from the witness. We actually work upon the demeanor. We see how the witness is reacting on which question put up by me has actually shaken the witness, or a witness is threatened by my such question, or he's not my question has made him uncomfortable. So I will stress on those questions, I will elaborate on those questions, I will put more questions related to that, so that he can the truth may come out, so he will not be in a position to manipulate things. And obviously the environment makes, though these are not the times when we can call a witness physically before the arbitral tribunal, but this is a problem, because when the witness comes to the tribunal is as good as a court. So he has this mental phenomena, mental thing in his mind, that he's appearing before a court. But when a witness is appearing virtually, he is sitting at his home, or he's sitting at a place where he feels most comfortable. So though a witness would be very comfortable, he's so comfortable that he becomes reluctant to make proper statements. He becomes reluctant to make a proper answers. So these are the difficulties we face day in, day out. But we have adopted it nowadays, and we are adopting it. And though I have already said that recording of evidence is not a mandatory procedure in arbitral proceedings. So in most of the cases where it might get complicated, or the witness might act against the interest to oversee the procedure of witness examination, and if the other party agrees, then the tribunal is empowered to pass to make any award on the basis of the documents placed.
Right, sir. Thaya sir, do you wish to add any point to this?
Yeah, I mean, in so far as the SOPs which Mr. Jaiswal mentioned, I think various arbitral institutions have come out with standard procedures for the
Yes.
holding of virtual hearings. For example,
Right.
the Korean Commercial Arbitration Board has come up with the Seoul Protocol for the conduct of virtual proceedings. And there have been similar rules published by various other institutions as well. Insofar as the proceedings themselves are concerned, I mean, I'm actually quite in favor of proceedings being held virtually. I think we have the technology now, and in fact, in many ways, virtual proceedings, I find them to be as effective, if not more effective, than in-person hearings. Concerns about the witnesses being assisted and things like that simply do not arise anymore, because you can have a camera that covers the entire reach of the room, one camera that is pointed to cover the entire room, and then another camera that's pointed at the witness. You can have a rotating camera so that the party itself can look around the room and see who's there. And then for various other steps, which you have in a hearing, I find that the technology can actually be of assistance. So you can have the documents in the bundles projected up on the screen you're looking at as well. Apart from the witness, you can have a live transcript of what the witness is saying, appearing on the screen while the witness is speaking. That can be particularly useful because depending on the particular witness, sometimes it is easier to follow what is being said in writing rather than in words. So I think it is an effective means of holding a hearing. Apart, and of course, apart from witness testimony, a lot of other things are done. Were traditionally done in person as well, like hearing various interim applications and all that. And that obviously is equally effective being done virtually as it is being done in person. So I'm very much in favor of it. And I think, some of it, even after the pandemic has completely come to an end, whenever that may be, I think some of it will live on. I think, like a preliminary case management conferences will be held virtually. I think a lot of applications in international arbitration for things like disclosure, security for cost, particulars, and all that will I think be held in virtually moving forward. Most likely, once this thing has abated and people are able to travel again, I think witness testimony, at least for significant witnesses, will go back to being in person. But a lot of, I think, arbitral proceedings, simply because of the time and cost advantages, may move, are likely to move to the virtual world.
Right, sir. So, whether this COVID-19 consequent action taken by states amount to force majeure, and if it, then I want to ask you that we had a reasonable time to understand what impact could this particular noble pandemic could have caused to the world. Still, if it still does this amount to force majeure?
Well, the question of whether or not something amounts force, at least in common law jurisdictions like India and Malaysia and Singapore and England, it's really a question of the interpretation of the contract. And it really depends on what has been provided for as being force majeure in a particular contract. So, usually contracts which have a force majeure provision deal with it in two ways. One, there's a general definition of what a force majeure event is, and that's fairly similar to the concept of the common law concept of frustration. So it's an event outside the party's control that could not have been reasonably foreseen and alters the performance of the contract. And then usually, after setting out those general requirements, the clause then usually goes on to give various specific incidents of what could amount to force majeure. And insofar as the specific events are concerned, obviously, if a pandemic is listed as a specific event, then that would bite, and the clause would come into force. Insofar as the general requirements are concerned, I think COVID-19, or in some instances not so much COVID-19, but the action that has been taken by governments of various countries as a result of COVID-19 is likely to result in a force majeure event, because it's clearly not attributable to either party. It's not something that could have been foreseen. So it is, in most instances, something that would radically alter the performance of the contract, and so it is likely that that it will amount to a force majeure event. I mean, at least a large part of my practice is in construction law. So during the lockdown, obviously construction sites couldn't be operated, and there's really very little dispute between the parties as to whether or not it amounts to a force majeure event. It's taken as accepted that at least during the lockdown, there was certainly a force majeure event because no work could be done at the site. The dispute is really now seems to be moving into whether or not the force majeure event is COVID-19, or whether the force majeure event is the government action that has been taken. The reason why that's the dispute is, at least under construction contracts, a force majeure event like COVID-19 allows a contractor additional time, but not additional money for the delay. Whereas something like a change in regulation can result in both additional time and money. So the dispute really seems to now be more whether what the event was, whether it was the pandemic or whether it was the subsequent government action that was taken.
Right, sir. Sagar, sir, do you wish to add something to this?
Yes, absolutely. No, absolutely, I agree with Mr. Baskaran. And it depends upon the contractual relationship between the parties, what they have agreed insofar as a force majeure is concerned. And it is a matter of bigger concern whether the COVID-19 is the force majeure causing agent or the lockdown imposed by the central government or the state
Right.
government or in, yes, that is a force majeure event. So it depends upon the contractual relationship from case to case. But yes, in all and all, we can call it a force majeure event, and the contractors and the contracting parties have, yes, been affected, but this is a situation which is beyond the control of all the parties.
Right, sir. Thaya, sir, I have one question pertaining to this itself. That assuming the contract is discharged by frustration or force majeure, would the arbitration clause to the contract survive?
Yeah. So, thank you, Kumar. So basically, an arbitration clause in a contract is, as a matter of law, as a matter of legal fiction, is independent of the contract itself. So it has a life of its own. So, and that's expressly provided for in Article 16 of the model law, and is then found in all jurisdictions that have adopted the model law, like India, Malaysia, Singapore, and Hong Kong. So even if the contract is discharged as a result of force majeure or frustration, the arbitration agreement, which has a life of its own and it's an independent agreement, although it's a clause within the contract, will continue to survive. And the disputes that have arisen from that discharged contract will then need to be resolved in accordance with that arbitration clause that continues to survive.
Right, sir. Moving forward with this, Sagar, sir, if the arbitration
Yes.
agreement survives, how will it be performed?
The performance of the agreement.
Yes, sir.
See, uh, after the, it depends upon contract to contract between the parties, what mutual negotiations they have, and if they want to, if they are not mutually negotiating on, or there is no mutual consultation between them, or they are not agreeing to a point, they may refer their dispute to the arbitration, because as Thaya sir said, arbitration clause and arbitration agreement are absolutely independent of the entire contract, and it has its own life. So frustration of a contract does not ipso facto means the arbitration clause has become null and void and ineffective. That is not the position. So arbitration clause remains valid, and the parties has the right to approach the arbitrator or right to approach the tribunal seeking dispute arising out of that particular contract, which has now become a frustrated one, or has become obsolete due to force majeure. As far as the performance part is concerned, it depends the contract performance of the contract, the mutual obligations of the parties, what they have to discharge as per their contractual obligations. So it depends upon the mutual understanding between the parties, if they have come to a point, because see, this situation, the pandemic situation, what we are facing is being faced by both the parties. The rights and duties of both the parties has been affected drastically. So if they are agreeing to a point, then it's fine. Otherwise, they can submit their dispute to the arbitrator, and depending upon the contractual relationship and subject matter of the contract, and what losses may have occurred or what losses might occur in future due to non-performance of such contract, it is the arbitrator who can either direct the parties to perform in accordance with their contractual obligations, or he can direct the parties to compensate the other party for non-performance of the contract. So it depends from contract to contract, and it will look as per the case comes before the court or the tribunal.
Right, sir. Thaya, sir,
Okay. Sir,
please.
Yeah, so, well, Kumar, I mean, insofar as the arbitration agreement per se, apart from the underlying contract is concerned, how it will continue to be performed, when the underlying contract has been discharged, and, in a time of lockdown and social distancing regulations. I think it's something we have discussed earlier in this webinar as well. But essentially, there are two aspects to it. Two things that will be disrupted in the arbitral proceedings. One would be, with regards to the service of documents, and the other would be, with regards to in-person hearings. So, the first problem is easy enough to solve, with regards to service of documents. A lot of arbitration legislation, like the legislation in Hong Kong and in Malaysia, allow for service of documents in arbitral proceedings to be effected electronically by email. So that's not an issue. Apart from that, even looking outside legislation in jurisdictions, if we look at the rules of various arbitration institutions, like the SIAC or the HKIAC, you will see that they do provide for service of documents electronically as well. So that problem is easily solved, and the documents can obviously be served electronically as a result of our social distancing regulations. Insofar as hearings are concerned, again, you have two aspects to it. One is the hearing of submissions, legal arguments, and on the other hand, you have the hearing of evidence. Insofar as the hearing of submissions are concerned, at least in international arbitrations, that is often dispensed with, because submissions are simply both opening and closing submissions are very often put in writing, to save the time and cost of party counsel having to travel simply to, present something that is in any event in written form. So again, that doesn't present a problem, and the submissions can simply be emailed across to the arbitral tribunal. Insofar as the witness testimony is concerned, again, that can be broken into two. One is, documents only proceedings are not something unknown in arbitral proceedings. They are found in most rules of arbitration, although they are confined to lower value disputes for expedited proceedings. But there is no reason why this procedure cannot be adopted for higher value disputes as well. Where there is a significant dispute on the facts, and a hearing is required, then, as we've discussed earlier in this webinar, virtual hearings can be held. The technology seems to be there, and everyone seems to be getting more and more familiar with such technology. 1 year ago, we would not have been having this webinar. No one was familiar with the use of Zoom. Now, I think it's maybe the 10th webinar I'm speaking on. So everyone is very familiar with Zoom, and everyone is very familiar with having virtual meetings and conferences and so on. Yep.
Yes.
Right, sir.
Parth, just one more
Sir,
thing to add.
yeah, sure.
Yes, just one more thing to add to what Mr. Baskaran has just said. When it comes to service of documents, I believe in international arbitration, we have, in most of the international arbitrations, we have the standard operating procedures for the service of documents via electronic mode when it is served through email or it is served through clouds. So it has to be password protected, and there are several measures taken to protect the confidentiality of such document and to protect the interest of the parties, because once those documents, if the system is hacked or if it is released in public, so it may cause an irreparable loss to the parties, and even some companies may be absolutely thrown out of the business. But as far as domestic arbitrations are concerned in India, in international arbitration, I said almost we have the position settled now. But as far as domestic arbitration is concerned in India, this is a grave concern, a grave matter of concern nowadays, because in most of the domestic arbitrations, and especially the arbitrations where though the amount of the arbitration is less, but the documents which are sought from the parties to the arbitration are of grave confidentiality or grave, they may affect the absolute IPR rights or of the parties. In such cases, I have not found in most of the domestic arbitrations a standard procedure placed by the tribunal. So if insofar as the domestic arbitration is concerned, the tribunal must adopt these standard procedures and for serving of the documents, because confidentiality is absolutely important, because almost all of the arbitration proceedings arises out of the contractual relationship, and those contractual relationship has most of the contracts between the parties have the confidentiality clause in it, or have the documents which are absolutely sensitive to the as far as the nature of the contract or performance of the contract, or nature of the company, or the functioning of the company is concerned. So service of such documents over internet, over email, over cloud, a standard procedure must be adopted by the tribunals, domestic tribunals in India, which I think is absolutely missing even during these times.
Yeah,
Right, sir.
can I just take that up a little bit as
Yes.
well?
Sure.
I fully agree with Mr. Jaiswal. I mean, I think there is has been a concern, about the use of electronic means of communication and virtual hearings. That there may be some compromise to confidentiality, and that is obviously a concern, because one of the primary benefits of arbitration is that they are confidential. And as Mr. Jaiswal mentioned, they very often involve matters that are particularly sensitive and require a high degree of confidentiality. So especially, during the early months of the pandemic, we actually did see, I think, widely reported breaches of confidentiality, at least using Zoom, which gave rise to considerable amounts of concern. I think since then, arbitral tribunals, arbitral institutions have worked out various procedures to try to safeguard and to protect confidentiality, and guidelines and SOPs have been published in that regard. And also, of course, various institutions also have now their own dedicated virtual hearing facilities, quite apart from the usual applications like Zoom and Blue Jeans and so on.
Right, sir. Yes, Arush, please. I believe there's some technical glitch at Arush's end. So, sir, I want to ask you a question pertaining to online dispute resolution, which we are practicing, which we were talking about earlier also. So, regarding the jurisdiction, when disputes are resolved online, questions as to applicable substantive law to dispute arises is, in case of international arbitration, it is important to distinguish four choices of law issues. First is substantive law governing merits of parties, contract and claim. The second is substantive law governing parties, arbitration agreement, and then the law applicable to arbitration proceedings and pre-trial stage. Sir, important element of pre-trial stage are discovery, interrogations, and collation of evidence in support to respective contentions of parties. And I believe this can be minimized due to ODR. So, what is your say upon this, sir? We'll take Thaya sir first, followed by Thaya sir. We'll be having Sagar sir. Please, Thaya sir.
Yeah, well, thank you, Kumar, for the question. Well, as you rightly point out, in international arbitral proceedings, there are various laws that would be applicable. The substantive law of the underlying contract, the law of the arbitration agreement, the law of the seat, and of course, the law of every jurisdiction where you may subsequently have to enforce that award. So, I mean, insofar as interim measures to support the arbitration are concerned, they would be governed by the law of the seat, generally speaking. So, anything which you need, in terms of disclosure and so on, be governed by the law of the seat. Certainly insofar as the concept of the seat of an arbitration is in a sense a legal fiction. So you can place any country you like as the seat of your arbitration, but you don't actually need to conduct your arbitration at that seat. So the venue and the seat are different. It can be different.
Right.
So in that sense, we already have that legal fiction now of a seat, which can be anywhere you like, and you would probably select a country that's very arbitration friendly, so that all the court-related proceedings will be in that jurisdiction. But what's interesting is that with online dispute resolution, you will have a further untethering of the arbitration proceedings from any geographical location, because you won't even need to have a geographical location for the venue. So, insofar as the venue is concerned, and you need all these facilities, for example, for a very complex virtual hearing, where you want to have a dedicated operator maintaining the video link, and you want to have someone putting up all the documents on a screen so that you can see them as the witness is being cross-examined. You want to have someone transcribing all the notes live, so while the witness is being cross-examined, you can see that as live notes appearing on the screen as well. So you will have, you can then select another jurisdiction, a very technologically advanced jurisdiction where all that can be done very cheaply. All these virtual facilities can be provided at a very inexpensive rate. And so in a sense, that becomes the venue that is untethered from the seat of the arbitration. So, I had a discussion on this a few months ago, where I was speaking virtually out of Bangalore, and I was saying, Bangalore would be, for example, an ideal location for that sort of online dispute resolution, because you would save so much cost by moving all that side of the arbitration. Just like you have business process outsourcing, you would have a sort of arbitration process outsourcing, where you would outsource, all that transcription and, maintaining a document presentation and maintaining a video link outside to a virtual venue. And it would present a huge opportunity for people who maintain these online dispute resolution facilities. I think it will be a niche area of practice where some people may be able to develop it very well. Yes.
Yes, Sagar, sir. So,
Yes.
do you also believe that this particular things, the elements which I talked about, is being minimized in ODR for speedy resolutions, which might lead in the failure of true discovery of true and correct state of facts?
See, as far as your question is concerned, let me begin with the seat and venue of the arbitration, which is a most debated topic issue, especially in India. It has always been discussed since the inception of arbitration proceedings in India. So seat and venue are two things, and Thaya sir has already discussed it. And in one line, we can say the juridical point or jurisdiction of the courts are governed by the seat, and the venue could be anywhere up to depends upon the tribunal or the parties. So as of today, when it comes to online dispute resolution, we can segregate the nature of arbitration proceedings into two types. One is you can have the judicial side of the arbitration proceeding, and you can have the technical side of the arbitration proceeding. So for judicial side, you must see law of which countries are law of arbitration of which country are so friendly or so easy to adopt, or for the tribunal to follow is very easy. And if you have to approach the courts in such jurisdiction, it would be very efficient. When you have to approach the courts, such should be very efficient measure for the parties. And when it comes to the technical side, you have to balance it in such a manner that maintaining the forum for discussion, maintaining the forum for appearances, service of the documents, witness examinations, the case management portfolios, the systems for the online reporting of cases and everything. So all this should be taken care of at a place uh, where you can get all such technical services very easily. So one can have the venue at such place, and the seat could be at any other place. The seat could be at the place where the laws are so friendly, and venue could be at a place where the technical advancements are so healthy, or technical advancements are so friendly for online dispute resolution. And when it comes to, as far as the discovery of documents or inspection is concerned, insofar as in online dispute resolution is concerned, it depends upon the tribunal or the forum which is conducting it mostly, because serving the entire set of documents is over the internet. Though confidentiality we have discussed, let's not discuss it again. But apart from that, when it comes to the knowledge of the tribunal, so the entire set of documents, so the tribunal must exercise its due diligence, and tribunal must exercise its powers vested with it to come to the conclusion whether such documents shared, or such the important inspections and affiliations which has been provided, whether they are placed what is the veracity of such documents. So it depends, that duty is enjoined upon the tribunal itself, or the forum which is conducting that online dispute resolution. The duty is enjoined upon them itself. As far as the process is concerned, I don't think this is an impediment, or this is something a challenge to the tribunal, or this is something which can act as a very big impediment for the process of dispute resolution, or it is I think it is an nothing but an alternative to physical dispute resolutions. And in India, especially during these times, we have seen, even before the pandemic situation, even before the lockdown, we have seen even the Supreme Court has regularly insisted upon, and even the legislature has regularly formulated laws for dispute resolution. If you have gone through, though we are discussing on arbitration, I'll just take a minute out of it. And yeah, if you will go through the Commercial Courts Act, so Commercial Courts Act Section 12A clearly states so you have to have pre-trial mediation, and that is a mandatory requirement. You cannot approach the court without having a pre-trial requirement. So online dispute resolution is nothing but a substitute to those measures of dispute resolution, and which I believe is a very good approach. And I believe it is if successful, it will have a great impact on the entire litigation sector, because most of the disputes which were earlier used to get settled after 4, 5, 6 years of litigation, or after 7, 8, 10 months of arbitration, they will be initially settled without going for any arbitration or litigation. So I believe such measures are an alternative and a beneficial measure for litigants nowadays.
Sir, last point
Sir,
to this.
one last.
Yes, please, Arush, please.
Go on, go on. Okay. Sir, as we are moving everything to technology, we are highly dependent on technology. There is a high chance of data breach. So, sir, are there any data protocols that we follow? Because hacking is something that is on the rise. Like the more we use technology, the more risk they are involved. So, is there any uniform data protocols, or what data protocols do we put in place in order to ensure the data? Sir, anyone can take this question. Open to both of the panelists.
See, I believe uh, we have already discussed it in detail when we were discussing the confidentiality thing. And as far as international arbitration, commercial arbitrations are concerned, I've seen in Russian arbitration, also in Malaysian arbitration, I believe it is there. So as far as international arbitrations are concerned, the data protection has been taken care of as on date, because they have the most of the tribunals has issued the SOPs. Most of the tribunals have a set format on which the documents has to be shared. They sometimes develop the the password protected clouds of their own to share the most confidential data, which breach of which may cause severe loss to the parties. So the problem remains when it comes to domestic arbitration in India. I have already discussed it. I know in very brief, I'll just point it out. When it comes to domestic arbitration in India, there is no set format as on day. The SOP is not in place, which I believe it should be there. Now, as far as the tribunal is concerned, there is flexibility with the tribunal. It depends upon the party autonomy. The tribunal can issue the procedural orders, because in one of my arbitration, I have done it. As an arbitrator, I am the arbitrator in that arbitration. So I have done it. So I believe when I am appearing before any other tribunal as a counsel, so I request the arbitrator there to issue the standard procedure so that my data is protected, and an undertaking can be taken from the opposite party also, and the system of the tribunal must be so uh, effective and so secured that a data breach may not occur. So in domestic arbitration, we face this issue even today, but in international arbitration, I believe it has been taken care of. Initially, there were issues, there were no SOPs, but now it has been taken care of.
Okay,
Okay,
sir.
sir. My question was pertaining, like, I knew that we have already discussed it, but I wanted to ask that is there any uniform protocol that we have developed right now? I
No,
don't think we have a
no,
uniform
no,
protocol.
no, we don't have it.
Uh,
Unfortunately, unfortunate, but we don't have it. The tribunals in India, the courts in India should develop it. There must be legislation can be put into place for it, but unfortunately, we don't have it today.
I believe Thaya sir has something to add to this. Thaya sir, please.
Yes.
No, just in response to Arush's question, various arbitral institutions have published protocols on virtual hearings and data protection. I think the International Council of Commercial Arbitration has also come up with a protocol on it, but there isn't a benchmark yet. I think various institutions are vying to capture the standard at the moment, but there isn't an international standard yet. But I think we are moving quickly towards that.
Sir, I have a question to both of you regarding the awards. So, like taking New York Convention as a starting point for analysis of whether electronic arbitral awards are admissible within current legal framework or not. So, sir, I noted that convention does not explicitly provide for an arbitral award signed and in writing. But further, Article 8 of UNCITRAL Model Law on Electronic Commerce explicitly states that requirements to present information in its original form can be met by an electronic data message. But in Article 31(1) of UNICITRAL model law requires award shall be made in writing and shall be signed by the arbitrator. Sir, what is I mean, do you guys wish to please just put some light upon this, that how these awards are enforceable?
I don't really see an issue arising from that, Kumar, because the award per se can still be in physical form. The individual arbitrator can write his award and have it printed out, sign it, and then simply email it to everyone. I mean, I think the fact that it's simply being electronically communicated across to everyone who would not remove the issuance or the publication of the award. Most several arbitration jurisdictions actually allowed for notice and publication to be done electronically. So, for example, in Malaysia and in Hong Kong, the acts expressly provide for electronic service and communication, which would include the service of the award as well. And insofar as other jurisdictions are concerned, the rules of arbitration in most of the jurisdictions in this part of the world, in India and Asia Pacific, most of those arbitral institutions, like in Hong Kong, Singapore, Malaysia, and in Mumbai as well, allow for service electronically. So I think that would cover it in my view.
Right.
Just to
Sagar, sir?
Yes, yes. Just to add to it, apart from the service of electronic service of the award electronically, when it comes to writing, as far as Article 31, as you mentioned, of unilateral model is concerned, which is adopted in Indian Arbitration Act itself, you'll find that award has to be in writing and has to be signed. So when it comes to the electronic mode, it can be writing means it can be written on the laptop, and it can be digitally signed also. So signing does not specifically means it has to be signed physically by the arbitrator. If the arbitrator has the digital signature, he can sign it digitally. And in fact, today I believe the digital signature is more effective than the actual signature on documents which has to be served electronically. So it can be signed digitally, and that digital signature is as good as signing it in physical manner, and that cannot be challenged. Such award cannot be challenged on those grounds, and service part has already been dealt with by Mr. Baskaran. So this is how the writing and signing of the award is concerned, and the service has already been done. So this is how the entire award can be passed.
So as you
Uh,
guys have given us such good answers regarding this, sir, we need to, as we are moving forward, so the audience can put up their questions if they have any on the chat, and until then we can have the concluding remarks from both the panelists. Thaya, sir?
Yeah, when the pandemic first kicked off, I think, a famous author in India, Arundhati Roy, said that the pandemic is a portal, and I fully agree with that. I think the pandemic is a portal, especially for arbitration proceedings. And as I mentioned earlier, I think it will have a permanent effect on arbitration proceedings. Maybe not so much on witness testimony, which may, at least insofar as significant witnesses are concerned, revert back to in-person hearings. But I think, in terms of the hearing of interim applications, case management conferences, and preliminary meetings, I think a lot of that will be held by way of video conference and virtually moving forward. I think it's sort of compelled or forced many of us to familiarize ourselves with technologies which we wouldn't have used otherwise. I mean, I suppose not many of us would have used Zoom or Blue Jeans or anything prior to the pandemic, whereas now everyone is quite familiar with it. So I think it is. I think it will have a permanent effect, and I think it's a beneficial effect as well. Yes.
Right, sir. Thaya, sir, thank you. Sagar, sir, please give your concluding
Yes.
remarks.
Yes. See, I believe desperate times needs desperate measures. So this is a desperate time, and post this pandemic situation, and when the normal functioning of the courts and the tribunals will resume, I believe that will be a different. Can you confirm I am not disconnected?
No, sir, you aren't. Your mic was just muted for some time.
All right. All right. So post this pandemic situation, the arbitration process will be absolutely different, because till date, as far as domestic arbitrations are concerned, because in international arbitration virtual hearing was an adopted norm, and it was in continuation for several years as of now. So
Sir,
as far as domestic arbitration is concerned, so after this pandemic situation, we will have a very different scenario, and we believe the tribunal and the parties, everyone will be very keen to adopt these systems. But just there is just one more thing I want to add, because in case of arbitration, if the venue is outside, if the venue is at a place where the council does not usually practice before, because see, for example, I practiced before Delhi High Court, and if I have to attend an arbitration proceeding before uh, in Bombay or in Bangalore, so I will have to travel to these cities. So uh, traveling to these cities will affect my entire cases and everything in Delhi on that day. So when I will get this opportunity and this facility of appearing virtually, so all this can be protected. The client will be the cost. It will obviously be cost effective, and that will protect the interest of the clients also. So only thing is that I believe the lawyers have mostly, by and large, the lawyers has already adopted this system, and they are more friendly to it now. And my only recommendation would be the tribunal needs to get friendly to it, and the infrastructure of the tribunal needs to be developed. One is the infrastructure, and the second is the arbitrator needs to be friendly with all the virtual hearings and alternative modes of physical hearing. And as I referred in the beginning, there is this clause 17 in the Indian Council of Arbitration rules itself, which states that the parties can appear virtually, and over telephone there can be a telephonic submission also. So all this should be taken care of by the arbitrator. If the council is not appearing, if the parties wishes to appear virtually, all this should be taken care of. And since arbitration is a substitute, uh, is an alternate to the conventional litigation, so these things should be adopted very easily, and it should be taken care of by the arbitrator.
thank you so much, sir. Sir, your remarks were really insightful. Both of the panelists were really insightful today. And sir, moreover, I wish that when this pandemic gets over, we can have another session post pandemic, and we can see that
Absolutely.
the recommendations that we have given today, how they have how much they were true, how much dynamics the COVID has played, and it was really a great session. Thank you for joining us. We'll end it here. Thank you, sir.
Thank
Thank
you.
you so
Thank you,
much, sir.
Kumar. Thank you, Arush. And very nice
Thank you,
to speak
Baskaran sir.
with you, Mr. Jaiswal.
Yes, same here, Mr. Baskaran. Great to have you.
Thank you.
Great.
Thank you very
Thank you
much.
so
Okay.
much, sir.
Thank you.
And it was our pleasure and privilege and our honor to have you both on board. And we
Thank
believe we
you.
can again have a session on some another insightful topic in near future. And you both can
Absolutely.
give us your views upon it as well, and your enriching knowledge upon it as well. Thank you
We
so
look
much.
forward to that. Thank you.
Absolutely. Thank you.
So we call it a day, guys. Thank you.
Thank you.